Pam, can you hear us in the room?
I can. Can you hear me?
Yes, awesome.
Okay, good.
I think
Okay, good.
I think everybody's here. So, Kevin, would you like to open it up?
This meeting is being recorded and or transcribed.
Kevin, can you?
Yep, there we go.
There you
That's
go.
a little better. Thank you. We will convene the October meetings of the committee meetings of the Board of Accountancy. We have a physical quorum present. In addition, we also have two members who are participating through the online process. And we will go ahead right to our agenda and commence our committee meetings with the licensing committee. And Pam Church is the newly appointed chair of that committee. And Pam, we've got a little bit of action here in your committee, so I'll turn it over to you to walk us through what we have here.
Yes, we have quite a bit of action. Let me ask, do we have people present? We had expected two to be at the meeting who have filed petitions. Are they present?
Pam, Mr. Katzman is present.
Okay. And does it matter what order I take these in? I was just going to go down the agenda. Is that appropriate?
Yes, I think just follow the agenda, beginning with the credit extension request and proceeding on through.
Okay. I will start with the credit extension request then. And if I might, I think I'll start with the two that are listed last. Because both of these deal with a similar issue. Now, I don't want to imply that we are considering them together because we would consider them individually, but they both are candidates who are in China and so are dealing with travel issues there. I believe today you received a memo from Wendy forwarding a message from NASBA that people in China will be able to sit in Guam. They do have to apply for a travel visa, but that will change the face in the future, but it doesn't remove what they have been through so far. So the first person is, and I believe it's ZHOU, Jiachi Joe, I believe it's pronounced. And this is an extension request where this individual has passed BEC and FAR. It expires 12/31/21 due to COVID, asking for a year's extension. And this person has taken BEC and FAR one time each and passed both, so would have two more parts to sit. And we could request that. Of course, one option would be to request a shorter time period, would be to approve a shorter time period, and then the person can certainly come back if there have been additional problems. So I'll open it up to the committee for discussion or other people. Comments?
While it seemed like it was a long extension under the circumstances and international travel, it might make sense to do it, or I might be more open to it, I guess. I'm afraid if we just go to March or so, we might have to be looking at this again, potentially. So that would be, I guess, my rationale for maybe agreeing to a December 22 or something a little further than just 6 months.
Okay.
Yeah, this is Janet. That was my thought as well. So, I mean, it does seem a long time, but we may be back again. I could go either way, I guess, if it were, I don't know, September or.
I was
December.
leaning towards 6 months because the Guam site is now open and it's relatively easy to travel there. So 6 months would give the person 2 3-month period, one 3-month period per part. And this person has had time to be studying, even though they could not travel. I sort of hate to set a precedent of a long extension because I think we will be, that will affect other requests.
Since we were looking at these two together, I'm trying to see.
Do you want me to move on to the next one before we decide? Is that appropriate?
Well, I was just trying to see how long this other one was asking for.
The other one has requested 6 months, and actually, the other one requests 6 months and actually has more remaining, has only passed one. So anyway, I was thinking 6 months. I think it may be worth it to look at it again if the travel visas don't work out or something, rather than opening the door to giving everybody with international travel problems a year. But that's, I can be persuaded. Any other comments?
Pam, do we know that the first person is in China? I mean, we've confirmed that they are in China.
Yes, I confirm.
Wendy, do we?
Yes,
Yeah.
I've confirmed that both of them
Okay.
are in China.
Okay.
Pam, this is Andy. I kind of agree with you. I think that 6 months, if we were to set this in June of next year, that ought to be plenty of time, especially with the Guam opening up. I think that is going to lift a lot of travel, a lot of cost. It's going to make it a lot closer to them, any students in China. And I truly believe that if we go past that we're really going to open up a can of worms with everybody wanting to go to the end of next year. But that's just my personal opinion. Obviously, I'm not on the committee, but that's what I was thinking.
Does someone on the committee want to make a motion?
I'll make a motion to extend his for 6 months. And I think that would be through June 30 of 2022, since it expires at 12/31/2021.
Yes. So they actually expire at different times, so we may have to take them individually.
Well,
so
I was only addressing
you're
the
only
first
addressing.
one.
Okay.
Yes.
Okay. Yes. Correct.
This is Kevin. One comment I would make is, we will not have a board meeting until July, so we'll have one intervening board meeting in March, I guess, or actually after busy season, between now and then to consider an extension. But it would not be until, I think our meeting in July is July 26th, so we do not have a June meeting. If we would need to act on a further extension. Might we consider maybe till July 31, which would give us a 2-meeting window to grant extensions if they were necessary due to the travel considerations?
I like that idea of the 7 months to take it to our meeting date.
Yeah, I think that's a good point.
Gay, do you want to amend your?
Yes.
Who had made that motion?
I did, Gay. I
Okay.
will. Can I just amend my motion for 7 months through July 31 of 2022?
Fine with me.
Okay.
Is there a second?
I'll second that. This is Janet.
Okay. Do we need a roll call vote?
We will. That would be preferred because we've got some members that are participating online and some in person.
Okay. Can we do that? Call the vote?
Pam Church,
Yes.
Janet Booger Davis,
Aye.
John Griesbeck,
Aye.
Gay Moon,
Aye.
Okay, so is that it? That carries?
Correct. So the first one is complete.
Okay. Second one is very similar. This is Mr. Quan Zong, and he has passed auditing, although he has attempted FAR, has not passed it. So he actually has 3 parts. His expired, let's see, 9/30/21. He is requesting an extension to 3/31/22, which is 6 months. He does still have 3 parts, and has been affected by the travel. So I'm inclined to approve his request. My concern is that's not very long to pass 3 parts. Now he came close on FAR. You know, he may be ready to go on that one and then have 2 more. But I don't know the situation. He has asked for 6 months, so I'll open it up for discussion.
Ma'am, I would consider the July 31, just to be consistent, and who knows how travel arrangements are gonna be.
I sort of like that in light of Kevin's remark. Janet,
Yeah, I could agree with that as well.
any opposing views as well? I should just say, is there any more discussion on that? Does someone want to make that motion?
I'll make a motion to extend his credits until July 31, 2022.
Second?
I'll second that. This is Janet.
Okay. All right.
Pam Church.
If there's no more discussion,
I'm sorry.
aye. No, I was ready. Aye.
Janet Booker Davis.
Aye.
John Griesbeck.
Aye.
Gay Moon.
Aye.
Okay, so that carries. Let's move on to Mr. Isaac Garrett. Mr. Garrett has sat for parts. He has been at this a while and went back to sitting in recent years. He has passed auditing, which originally expired 6/30/21. It was extended to 9/30/21 under the blanket COVID extension. He had anticipated taking exams in August and September, but notified us that he was not able to do that because of the Delta variant. He has supplied a doctor's note verifying that he does have underlying comorbidities that would make COVID particularly hazardous for him. So he is requesting an extension of the auditing to March 31st, 2022. Due to, he would say, medical documentation of comorbidity. And I will say he talked about the enclosed area, and that due to his medical condition, he just really did not feel like he could sit during Delta. So is there discussion?
Well, it looks like he's in Memphis, and
It's not good, is it?
you know, it's not good. I don't know that Mark.
It was not at that time, particularly.
Yeah. So I guess I'm kind of thinking, would we want to extend longer for him?
Would we want to go to the same July 31st date?
I would not be opposed to that.
So that we wouldn't have to reconsider?
Yeah, given where Tennessee is, we aren't making a lot of progress.
Well, also, I don't feel that we're in a position to judge whether it was hazardous for him to sit for the test. I feel like that's an individual situation between him and his doctor. So I would be inclined to do the July. What about other members?
I think that's fine. I don't have a problem with that, and consistent with the others.
Okay. Can I have a motion?
This is
Motion.
Janet. I'll move that we grant him an extension to July 31st, 2022.
Second?
Second.
Roll call vote?
Pam Church,
Aye.
Janet Booker Davis,
Aye.
John Griesbeck,
Aye.
Gay Moon,
Aye.
Okay. Our next one is Curtis Hunt.
This is gay, and I need to recuse myself from this one.
Oh, okay.
Okay.
All right. This candidate's auditing score was set to expire September 10th, 21, was extended to September 30th, 21, about 20 days with the blanket extension. He's requesting a 3-month extension to 12/31/21 to complete FAR and Reg due to difficulty scheduling in the summer of 2020. So he has he has passed audit and BEC. The extension he needs is on auditing. He said he has not been able to complete the final two. And I'm saying this wrong. He has completed audit and BEC. He needs FAR and Reg, and he has said he was not able to schedule those because of difficulty in scheduling for the summer of 2020. So his note said, I'm reaching out in hopes of possibly getting at least 3 months where we were not allowed to sit and take our exams during COVID added to my existing audit credit that's set to expire as of September 30th, 2021. So he did not provide specific medical documentation, just cited the difficulty in scheduling. So I'll open this one up for discussion.
Well, this is Janet. I guess even though he didn't offer much more detail, pretty much 2020, I guess we know that wasn't a very good time. So if we did 3 months, that would put him to the end of the year?
That's what he has asked for.
Yeah, where is he? In Nashville. I mean,
so think about precedent, think about what we discussed when we set the automatic extension. Does that already cover those 3 months? Would we find it necessary to extend everyone 3 months? I'm extremely sympathetic to this, but I'm also very aware of the precedent we're going to set, whichever way we go.
So do we have a current, I can't remember, we have a current blanket extension through the end of this year?
Wendy, would you refresh us on the history of our extensions?
Sure. Extensions were granted to anybody within the pipeline that had scores expiring April 1 of 2020 through September 29th of 21 were extended to September 30th of 21. So in this particular circumstance, he sat for a part of the exam just before COVID shut everything down. So he received 20 days as a result of the blanket extension.
So do we currently have? No, there's no blanket through the end of this year. Is that right?
Correct. The blanket extensions ended September 30.
September.
He did say that he took one part September 30th, did not pass that, and had just decided to give up on the CPA exam, but his work encouraged him to continue, so he just recently passed the second part. So it sounds like he kind of renewed his interest in taking the exam. And maybe that could be an extenuating circumstance that he had changed his plans. I don't know. I'm looking for a reason why this person would be different from everyone else we gave the blanket extension to.
Well, I guess I mean, to me, given COVID, I guess I would still be of the mind that, you know, even if they do need more time, that it would be, I guess, helpful to give it to them under the circumstances if they ask.
Are you
for
thinking the 3 months that he asked for?
Yes, which would go to December 31st. That's my thoughts on it.
Okay. Do you want to put that in a motion?
Okay, I will move that we give Curtis Hunt an extension through December 31st, 21.
Is there a second?
Second.
All right, roll call vote.
Pam Church,
Aye.
Janet Booker Davis,
Aye.
John Griesbeck.
Aye.
Okay, and the last one of these extensions is Christopher Smith. Christopher Smith has an auditing score that was extended to September 30th, 2021, and that amounted to a 6-month extension, and he also has a BEC score that was extended to September 30th, which ended up just being 22 days. He, let's see, so he just lacks, he has passed auditing and BEC and reg. He needs to pass FAR, and he had scheduled this part, the FAR, for September 28th, but he wrote a letter saying that his wife is a nurse and she was diagnosed with COVID about that time, and so he took a test and actually tested positive. So could not go to the site to test. Let me get that note, that date.
He had, I guess we got a COVID test for September 24th was the date.
24th, that was it. And he was due to take this the 28th. So you know, when I was thinking about this, I thought, well, you know, people often plow through illnesses. However, with COVID, I think it would be inappropriate for somebody to go expose others, if nothing else.
Right.
And so he did enclose his test for that. So he's asking for an extension to be able to sit for FAR.
Doesn't look like he asked for any specific time frame. But
I don't think he did either, Janet. No.
But I guess I would think, I think to December 31st as well.
Mm-hmm.
Where is he?
Yeah, because he was studied and ready to take it.
Yeah.
So that seems sufficient, and it's just one part.
Right.
And it wasn't a period of time. He doesn't talk about being, terribly ill for a long time. It's just that he could not go that date.
Right.
Other discussion?
My only question would be, we did confirm that he was scheduled to sit on September 28th.
That's what my note says. Wendy, is that correct?
I am not sure if I confirmed that.
Yeah, that's what he said in his email, but yeah, I don't know.
Yeah, I don't recall if I did confirm that. I can certainly do
Well,
that.
I will say this. He, okay, I guess that would be relevant. His auditing would have, his two parts would have expired the 30th.
Right.
So the COVID diagnosis came late, meaning he had requested this extension far before he had COVID.
He had.
And so
That's right.
I guess that's maybe why it caught me off guard.
Okay.
Because I had prepared everything to send this to the board, and then he contracted COVID and couldn't sit.
Okay.
Because I think my initial question was, well, you might not even need this extension if you pass. So no.
Yeah, he had said, in his initial letter, he said, I am currently studying for FAR during all my free time and hopefully will pass the exam on my scheduled date. However, I'm requesting an extension as a precaution. So he had requested that. I don't have a date on that letter. But then on the 29th, he wrote and said, I was not able to take it, even though I was scheduled. So two different letters referred to having been scheduled.
Hmm. This is the one whose wife is a nurse?
Right, and that's why he took the test, was because his wife had been diagnosed.
Well, yeah, and I guess as a precaution, I guess he could have, since she's a nurse, she's always exposed, so I guess that could make sense that he would be thinking he could get it at any time.
True.
Anyway.
But she did test positive right at that time.
Yeah.
She tested positive 9/21.
Mm-hmm.
And he tested positive 9/24.
Yeah.
I think 3 months is not too much to ask.
I would agree.
But
That's your 3 months going to December 31st?
That's what I'm thinking.
Yeah, I agree with that. I'm good with that.
I agree also.
Would you like to make a motion? I'm sorry?
I'd say I agree also, but I can make a motion to extend until December 31st, 21 for audit and BEC.
A second.
Second? Okay. Can we have a roll call vote?
Pam Church,
Aye.
Janet Booker Davis,
Aye.
John Griesbeck,
Aye.
Gay Moon,
Aye.
All right. So that's all the credit extension requests. We will now move to the request to allow self-employment experience to meet licensure requirements. And this is David Kaufman, who I believe is in attendance. So he is interested in applying for the CPA exam. Most of his experience has been in a self-employment capacity. and he's asking what type of documentation he would need to verify that type of experience. The rules indicate that to have experience approved, that one has to have his or her experience verified by a licensee as defined in the Act or a licensee from another state. They don't specifically address self-employment, and we're not aware of any prior discussion or action taken specifically about self-employment. So the rules state that, let me pull out the rules. But anyway, the person does not have to be within the same organization, just has to verify that person's experience. And the experience can be in various areas. The experience does not specifically have to be public accounting, for example. So this individual, Mr. Kaltzman, does have a bachelor's degree in accounting from Indiana State, has been employed as a police officer with the Metro Nashville Police Department since 2007. Before that was a staff accountant for a firm in Indianapolis. From 2012 to 2017, he was also self-employed part-time preparing tax returns, and during that time prepared a total of 347 tax returns. He also attained the designation of enrolled agent, but said that he has now let that expire because he stopped doing taxes. During the most recent 3 years, 2015 to 17, that he prepared taxes, he prepared 223 tax returns in total and worked over 2,000 hours on his tax preparation business. He states that he's interested in taking the CPA exam in order to further his career with the Metro Nashville Police Department. Since his duties currently are not accounting related, though, he would need to count some of that past experience to qualify him to become a CPA. So the key point, I think, is that the rules say a licensee needs to verify the experience. And we're being asked to consider whether self-employment should be considered toward the 1-year experience requirement, and if so, what documentation would be required. And I would add the question, does that change compliance with the rule that someone, a licensee, should verify that? A question was raised as far as the board serving as the licensee, so you may want to consider that as well. Maria, do you have input to this from a legal perspective?
Yes, thank you, Pam. So Wendy and I discussed this in advance of the meeting. The language in the rule is that the applicant shall have the experience. There's no discretion for the board to usurp this requirement that the experience be verified by a licensee. I think today we could discuss what you all might want that to look like or suggestions for him to go forward on this. But the board couldn't, as a conglomerate, stand as the licensee to just waive that verification.
Okay.
We even discussed, well, then an individual board member working with the applicant to verify, but that would be, could pose an awkward situation. But it would have to be a licensee verifying the experience. So I think it'd be helpful today just to focus on how you all might want that to look, or whether the self-employment would be acceptable in your discussion. So does that answer?
Would one of our investigators be considered a licensee to be able to verify his enrolled agent license and the other experience?
Janet, I'm so sorry. I didn't hear the first part of your question. Can you repeat
Well, I was just wondering if one of the investigators could serve as the licensee to verify his experience.
That would totally be up to Sherry, and she is the licensee, so it meets the rule. that would have to be something that, Sherry would have to see if she's comfortable with, and also Wendy would have to, I guess, consider. She's certainly qualified.
Maria, can I ask what the person who is verifying the experience, what does that person have to sign? So in other words, does that person have to be personally familiar with the experience? Do they have to sign anything saying I am personally familiar with it, or just say this person did this type of work and I'm satisfied that this person did and therefore I'm verifying it?
Pam, the licensee does sign a form indicating that they are personally familiar with the applicant and the duties that qualify them for the 1 year of experience.
Then Sherry couldn't do that, right?
Say that again?
Because she wouldn't be personally familiar with this person.
No, that would be up to the board. We have, she may be able to interview him. She may be able to confirm his enrolled agent status. I'm not sure if you can do that for a time period. So there may be ways. I know some states work with NASBA, where NASBA has an interview service that they allow, where they allow somebody to interview with someone to determine whether they meet that requirement.
Well, I guess I thought you said the rule said they had to personally be familiar.
The rule does not say that. The rule says that...
Or this affidavit that the person would have to sign. Oh, but you're saying, then that's inconsistent then.
Could it be a client?
Yeah.
So if this person had a client who is a CPA, that person might be qualified to verify. Well, let me open it up for discussion. And does anyone have any questions of Mr. Kautzman as well?
This is Kevin. One question that I might have of Mr. Kautzman would be, you had mentioned that you had prepared a certain number of returns during certain periods of time. Would you have billing or correspondence records associated with those returns that could be reviewed by a licensee?
Yes, I've still got all my records for my all my business records with customers and their names. Of course, I don't know that I could provide client names. I'm not sure with regulation. Give numbers and remove identifying information, I suppose.
Okay. And would those records include, I don't know if you billed by the hour or not, but would they include any kind of a record-keeping thing that would indicate, aggregate number of hours that were spent over that period or in any given year?
I don't believe so. Everything I did was just a flat fee based on a meeting with the clients and a judgment based on the complexity of their.
Okay.
So it was all just I gave them a price, a flat fee up front.
Okay, understood. And I would, this is a little bit off topic, but I'd be remiss, sir, if I didn't say thank you for your service also with our police department here in metropolitan Nashville. I realize it's not directly related to the issue at hand, but it is, your service is appreciated.
Yes, sir. I'm happy to do it. Thank you.
Do any of the committee or other board members have questions for Mr. Kautzman while he is here? Greg?
This is Janet Booker Davis, and in my own practice, I sometimes refer to other CPAs or work with them, and so I'm just wondering, are there any CPAs, licensed CPAs, who were aware of the type of work you were doing?
Yes, ma'am. My wife's uncle is an accounting professor at North Carolina State. And he's a tax professor there, and he provided me with a lot of guidance on preparing taxes and research and provided me with a lot of study material as well, reference material.
Is he a CPA?
Yes, ma'am.
Okay.
Well, it says the licensee can be from another state. Is he willing to be the person to verify?
I would be happy to ask him. To be honest with you, I wasn't sure if that was even an option, so I would be happy to ask him.
The rule says the applicant shall have his or her experience verified to the board by a licensee as defined in the Act or a licensee from another state. So, Maria, am I interpreting that correctly?
That is correct.
That may be.
Do you have? I'm sorry.
Go ahead, Pam.
Mr. Kaufman, do you have documentation that you were in fact an enrolled agent?
I'm sure I do at home. Yes, ma'am.
This is Rob Vance. I have a question. I'm not a tax return preparer anymore, but is there some sort of an IRS printout that you can get on electronic filings or something along those lines to show that you've actually done all this work?
I believe so.
I mean, is there not? I mean, I don't.
I'm not sure how far it goes back or anything.
Okay.
Third-party
verification.
Tax lady.
Well, I mean, we have a PTIN, which I'm sure that you have that, but I don't know that there is a way to extract the number of returns associated with that PTIN number. But I also want to thank you for your service to our great city and keeping us safe. And I think the North Carolina CPA would be great if he could provide that verification. But if not, I can't tell you how many people are looking for tax preparers. And if you did start your exam, the process of taking the exam, I would think that you could find any kind of people that would want you to help them in preparing tax returns. So, I mean, the process of taking the exam is not next 1 month process. So I feel certain that if we can't get this letter from the gentleman in North Carolina, you would not have any trouble meeting your experience requirements.
Thank you.
Mr. Kaufman, Mr. Vance asked an excellent question on the e-filing, and I know that some of the tax software packages actually track that, and you can get a summary report of the number of returns that you e-filed during the year. I think they list the client names, but I think if you, for example, asked your wife's uncle to verify and help participate in this, I would think would be free to share some of that information, at least the summary information with him as evidence of what you've done.
Yes, I'd be happy to do that. To be honest with you, I wasn't sure what kind of documentation you would need, but I'd be happy to put together, for lack of a better word, a case file for you and get that done.
Let me pose this question. Would we require any different documentation than if he had been employed? Are we sure that people have not just gotten their experience verified by someone if they were self-employed? My question is, would we require different documentation, or do we rely on the licensee, in this case in another state, to be the judge of that?
Historically, we have relied on the licensee to determine that based on the rule, and if they have questions, they would typically call us to determine that. But they simply have to note that what the duties of the individual were, that they were personally familiar with the work that the licensee or that the candidate did, and then they sign off on it, providing their contact information. So I think
it's a matter of your convincing this person that you did work sufficient to count. And notice it does have to be within the 10 years preceding your latest application for a certificate. So it sounds like you have ample experience, but I wanted to point that out.
Thank you very much. I appreciate it.
Are there any other committee or board member questions for Mr. Kautzman while he is kind enough to be here with us with respect to his request?
I just have a quick question before we finish this, just to make sure that we've answered your questions. Does this help you moving forward?
Yes, I can put together this documentation and have my wife's uncle go through whatever he needs to go through, and I'm not sure where I would get this affidavit, but I could certainly.
It is something that a candidate has completed at the time they're ready to apply for a license.
Okay.
And so that would be something not until you pass the exam that you would work on. And so I was just making sure you didn't need anything else from us before that.
That sounds great. Thank you.
Mr. Katzman, again, we appreciate your service in the law enforcement community here in Nashville, but also appreciate your taking the time to think ahead and say, okay, what will I need, in order to get this done? And we wish you the very best success, not only in your current law enforcement career, but if you choose to go forward and take the exam and apply for a license, we wish you success in that endeavor, and are appreciative of those who take the time to try to look at the rules and make sure they're doing it right, which you have done. And that's just so greatly appreciated by this board.
Thank you for hearing me today. I appreciate it.
You're most welcome.
Thank you for your attendance. And Wendy, I assume that there will be sufficient documentation so that if it is a while before he completes the exam, that he can refer back to this deliberation to support his, if there are future questions. Does that make sense?
I will have Karen make sure that she adds a little more detail in the minutes of the board meeting.
Okay.
Since we aren't taking action today.
Right. I think that would be prudent.
Right.
Thank you.
Yeah, sounds good.
Okay. All right, let's move on to consideration of firm names. And we have two that do both deal with a similar issue, and that is the use of acronyms in the name. So the first one is a consideration of the firm name KLLW, and I think the title at the head of this letter has an initial wrong, but it's KLLW. This is Mr. Drew Lamb. Am I correct that Mr. Lamb is not in attendance, Wendy?
Correct. I don't see him here.
Okay. So the staff brought this forward because they were concerned that the name might not comply with the rule 0020-03-.15, which says, let's see, there are two relevant parts. Reasons the firm name may be considered misleading include but are not limited to, and one of them is including information about or indicating an association with persons who are not members of the firm, except as permitted pursuant to a different rule. And then further down it says the following types of CPA names are not in and of themselves misleading and are permissible as long as they do not violate any other provisions. And it says a firm name that contains an acronym if all the words that create the acronym meet all of the other requirements. So in other words, if there are initials in the name, if it's an acronym, that's okay if the words or names they stand for meet the requirements. And so it would refer back to the rule I read initially saying you cannot indicate information about or indicating an association with persons who are not members of the firm. And so this KLLW, actually, Mr. Lamb explained that this is a name for our business purposes, just 4 letters that convey the idea of hopeful accountants wanting to change the accessibility for women and minority-owned businesses in financing, CFO services, generational wealth, and accurate bookkeeping. And so he explains that they were studying accounting at Vanderbilt, and that he and one of the other people have taken the name of all with the initials of all 4 to make this firm a reality. The other 2 are not involved in this organization, although they have the right to buy in if they so choose. So these are the last names of those students who are all CPAs in their respective states, but the name does not imply that they're all CPAs, he points out. So he gives the last names. He said it started with origination point in mind in our operating agreement between himself and Kahan. We do have it as that the partners, the other two, if they so choose, the other two could become part of the partners if they so chose, and they remain advisors for the firm, but they are not part of this. So he includes the firm permit application. So I'll open that up for discussion. Is this prohibited by the rule for names of people who are not members of the firm?
Pam, this is Gay. I don't have a problem with the initials. I guess my question is, how is an LLP only have one partner? And to me, that's where it's kind of misleading. LLP, I mean, that relates to a partnership, but we're saying that there's only one member, and that is one of the areas implying the existence of a partnership when there is not a partnership. LLP does show that. To me, that's what the problem is with the misleading part of it. It's not that it's KLLW, it's is there a partnership or not?
Wendy, do you have input on that? He is, in fact, the only member.
It's on the Secretary of State's filing information, and it has partner count, and it has...
That's right. I mean, that's not an error, right? And it's funny because he does refer to the second person and says that both of them made it a reality. So my guess is that person's involved but not a partner.
So the ownership form that I provided may not be showing up on the iPads correctly, but it was a fillable form, and Mr. Lamb indicates to be the 100% owner of the firm.
Right. Right. So why does he refer to the second person in the paragraph where he explains the whole situation?
He indicates there's an operating agreement.
CPA.
He indicates there's an operating agreement. I'm sorry.
Mm-hmm. That's what I'm thinking too. Go ahead.
Well, the operating agreement indicates that there's a second person, an operating agreement between the L fellow and then the K fellow. I'm sorry, the Lamb and Kahan. But then the application, as Wendy indicates, is in contrast to that, says that there's not two partners. They're not two limited partners. So I'm a little confused. They seem to conflict each other.
Well, see, and I do have a problem with the KLLW because you're not supposed to imply that people are involved who are not involved.
But there's nowhere where it says CPA, and so in my mind, you know, if it was KLLW CPA LLP, I would agree with you. But there's nothing that references CPA in the name, so I mean it could have been any group of letters. In my mind, those letters are not that meaningful, but. Especially since... So
you're thinking it's not misleading because no one else would know what they were for anyway.
Exactly. I mean, yeah, exactly.
So it's really no different from a firm name like Aprio, Catalyst, any number of them that...
Or ADC.
ABC.
ADC, so it's at the top, towards the top of the list.
And what if he was an LLC here? Would there be any objection instead of an LLP?
Well, LLC can be a sole member, I have no problem with LLC.
Right, I agree.
It's the LLP that indicates it is a partnership, and that's where my problem comes in.
Are there legal issues we're not thinking about, Maria or Wendy?
No, it seems like you all have a good understanding of the rule and how it applies in this situation.
I believe we advised that he initially didn't need a firm permit, but they indicate an interest in getting involved in the provided test services, and so of course they would need a firm permit if that's what they would like to do.
Well, wasn't he saying too that they may expect to have, I guess, admit other partners, and maybe that's why they did the LLP? Even though I guess they only have the one person now, based on what's documented.
Possibly the Secretary of State. I know that people put in those numbers and they can type in. I just recently went through that with a client, and she put in the wrong number of members when she was doing her annual report. And so maybe that's something to ask, since he does reference an operating agreement and he talks like that. It's a partnership, but the Secretary of State document does not reflect that this is a partnership.
Well, no, it theoretically doesn't if he's 100%.
Well, and neither does the ownership form that he submitted indicating he was the 100% owner.
The sole owner. Well, maybe he needs to get his paperwork fixed.
Right. So can we vote then? Should we take a vote? Should we take a vote on the name KLLW and indicate that the form of ownership has to be in compliance with the law? Would that be appropriate, or do we not vote? What do we do?
Yeah, I think this is Kevin. One possible way of dealing with this is that we know, based on what has been pointed out in the discussion, that there's a disconnect between the LLP aspect of things and the 100% ownership that the state filings indicate that he has. And so, rather than taking a vote affirmatively to, award him a firm permit with this name, I think the first thing that has to be resolved on their end is their legal structure and that nomenclature. And then perhaps when we're communicating to them that, we can also, remind them of the notion that of the rules as it relates to the acronyms. Because really, if we vote on the acronym, we can't really award a firm permit now, given what we know about the legal structure conflict, until that's resolved. And so I'm not sure it makes sense to vote on the acronym, in my view.
Yeah, I agree with that. I think we need to clear up the name, the legal structure issue first.
Okay. All right, so no vote on this one.
Yes, and so does that mean, Wendy, you'll get back with them about the issues that need to be cleared up?
So,
hello.
This is Andy. Just a quick question. Should we ask for the business agreement that they have, since they have this side agreement, to ensure that, to be able to review that?
It would be interesting you don't have an operating agreement unless you have a second person.
Right. That's
so
that's what
to
still
state the obvious. So I'd like to find that out. And if we're going to give them some sort of instruction letter or whatever it might be, remind them that they cannot use the CPA in the name under that current name, the acronym. Right? Am I correct about that? I mean, I think that's the way I read the rules.
But could we also not ask for a clarification from the state that they get clarification that an LLP can only have one member? Because I know from IRS standpoint, they're not going to file a partnership return.
Typically, we simply respond to the applicant with what's needed.
Right.
And a lot of times we just say this is not in compliance with the rule and let them go back and figure it out. But we can certainly say we need more information based, your form doesn't match with the ownership information that you've provided. So that's the first place to start.
Well, and probably just tell him that we were unable to consider this firm name firm permit because it violated the form of ownership. and just let them come back. All right, are we ready to move on?
I guess the other thing would be just before that, do you think we even need to check the agreement? If there's a business agreement, it probably is between two parties that implies something. Would it be logical, or would that be something that we normally ask? Or
We ask for the ownership form, and we typically do file the Secretary of State just to make sure everything matches.
Okay.
Is what we do to make sure we're meeting that part of the rule. I do think, Karen, when he first applied in CORE, he listed KLW without LLP on the end. But then when he provided the ownership form is when he added, and the Secretary of State information, it had the LLP on the end. And so I don't know if it makes any difference if he's advertising firm KLW without any indication of his legal ownership, if that makes any difference.
But in his application, did he say he was the 100% owner?
Yes. Yes.
Okay, well, that's in definite conflict then. One of them's wrong.
Yeah.
So.
Anything else?
I mean, I guess the only other thing I would say is that's kind of a legal issue, how he does this name and the filing and what's accepted with the Secretary of State. And, I mean, is that our place to comment on legal issues like that?
Part of the rule is that you can't advertise yourself in a way that is misleading to your actual ownership structure. And so that would be concerning to this board if he was operating as an LLP to the public when in fact he doesn't meet those requirements, or there's just one owner. And so I think we're just going to have to go back and get some more information. We thought he was going to be here today. Maybe he misunderstood and he's going to come tomorrow. I'm not sure. But we don't want to look at the KLLW portion of the question without the ownership. So let's say he gets that part resolved. Do you all want me to bring the KLLW back to you, or do you want to vote on that aspect of it?
Are you talking by tomorrow he might get it resolved?
No, I mean, if in a week or so we have communication with him, how would you like us to proceed? Let's say he resolves the ownership portion of the problem.
And so, in other words, all that we're left with is the KLLW acronym and whether that makes sense. I don't know that it's appropriate to take a vote on that because we don't really have it properly positioned before the board, but we can certainly get a sense of what the committee and board think about that and maybe provide, if we kind of throw up all over that and, it's not going to fly, we can tell him that when we have our communications as well, or if there's a sense that the board and the committee are comfortable with that. I guess we could communicate that, but I really don't know that we're in a position to take a formal vote on a license or a firm permit application yet.
He's got to resolve one of two things. Either he's not an LLP, or if he is an LLP, he's got one other owner, or if he doesn't, then that's in violation. If he does have a second owner, he indicates that it's the K person, the K-Han, and I'm assuming we're assuming he's a CPA, so that means there's two CPAs that are owners and two people that are not owners in that KLLW. So either way, I think there's a problem with it. I mean, that's the way I see it. Even if he's a sole owner or if there are two owners, I think there's a problem with it. Because if there's two owners, then you have four letters but only two owners, if there are two owners. And that's in the speaking part. That's just what he says. His issue is that we want this because there's four of us. So I just think it's a problem either way. So
if they don't advertise, if I'm not on the committee, but if they don't mind, if on the website they're not, I don't really follow this description of the name anyway. But assuming it does represent people's names, if they're not otherwise advertising these other individuals, to me, it could be the first letters of vegetables, and would we have a problem? So I think we don't ask for their, marketing materials or anything, but I don't know that initials by itself necessarily have to be misleading. But, if they're really a group and that's, they're going to put all their bios on the website, then I think it would then imply. So it's hard to just look at it in isolation. So I totally agree that it seems premature to try to take action given the layer of questions and issues.
Can I ask a question, Maria? I think this would be for you. But that part that says a firm name, now this, let me precede this. It says the following types are not in and of themselves misleading and are permissible so long as they do not violate any other provisions. A firm name that contains an acronym if all of the words that create the acronym meet all the other requirements. All right, when it says words that create the acronym, does that mean the words that the letters of the acronym stand for?
Well, I certainly think that would be up for interpretation, but I kind of look at it more as going back to the CPA piece, that it's not, KLLW, no space, CPA. And then that creates something that is misleading. I'm of the opinion that just the letters in of themselves are not misleading, but that discretion is up to you all as board members. So that's within your purview to decide whether or not you think that is acceptable.
So I think we would have to consider this once the other issue is resolved, because it sounds like there will be a discussion. So I just don't think we can take any further action today or give any other instructions except to fix the type of organization and bring it back. Do you agree?
And it doesn't necessarily mean, I don't think we're asking him to change his entity type. Perhaps that's the way he has to resolve it, as opposed to clarifying that if you are in fact intending to be an LLP. I was trying to look on the code on the phone, but it's not very user friendly. But I haven't looked at the LLP Act in a while, but I mean, it's pretty clear that it's an association of two or more people. You just happen to have so he's got a bunch of things he needs to clear up here.
Yeah.
Right.
Just because the Secretary of State's automated system allows you to create the entity doesn't mean it's necessarily statutorily compliant.
Yeah.
Okay.
He has a problem with the IRS regulations, period, because I'm looking it up, because Kay is exactly right. It's in violation of the regulations. The LLP implies more than one person.
Same under Tennessee law.
I think, Wendy, you have some guidance from the board to go back and urge the applicant to address those matters, and then once he's done so, he can bring it forward. Yes.
All right, so I will move on to the next case, which has some of the same issues. This is a Mr. George Fuller, who has applied for a firm permit under the name A3 Accounting Services, LLC. The staff believes that this may not be in compliance with the rules, and it is the same one. Board rules allow the use of an acronym in a firm name if all the words that create the acronym meet all the other requirements of the rule. Mr. Fuller provided the following explanation regarding the firm name. The A3 Accounting Services name is in honor of my three daughters, Alexandra, Ariana, and Andrea. I also chose it because I thought that A3 Accounting would show up closer to the top of the list when people are looking for a firm online once I create a website. When I looked at the regulations, I thought accounting would be appropriate. So this is a similar issue with an acronym of A3 that we know refers to three daughters' names, but it does not say so in the name, and I will, and let me say, there are two people with equity, George Fuller and Gerald Fuller. So I will open this for discussion.
This is Gay. I don't have a problem with A3. I mean, he said we did it so we'd be at the top. I mean, I realize it acknowledges their daughters, but he said he did it at the top for Google or searches. And accounting, he is a licensed CPA. He does own 51% of this LLC. And is that, I can't remember, Wendy, is that 51% is okay for two people and to have accounting in their name?
A simple majority must be CPA ownership.
Okay.
And it's his wife that
Yeah.
he's owns it with.
Okay. I don't have I don't have a problem. If we've met.
This is Janet. I didn't see any problem with the name either.
Yeah, and what's okay with me, I'm not, of course, voting, but the fact that they don't work in the firm is another reason that the A3, whereas the other names, they were actually in the firm working. But he could have done AAA accounting.
I mean, how would you view it if you did not know that information? If he just came and said A3 accounting, you had no clue that it related to the daughters. I'm not sure we'd care.
Yeah, I don't think we care.
I don't have a problem with that. You have no idea what it's referencing,
Right.
really.
Mm-hmm.
And like you said, it was to get it to the top of the search engine.
I'll make a motion that we accept this name.
Is there a second?
I'll second.
Can we have a roll call vote?
Pam Church,
Aye.
Janet Booker Davis,
Aye.
John Griesbeck,
Aye.
Gay Moon,
Aye.
All right, so that carries. We have one more issue. This is consideration of the Certified Associate Project Management Exam for CPE credit. And the key issue is that this is designed for entry-level project managers and is administered by the Project Management Institute, which is the same organization that offers the Project Management Professional Exam, for which we already have approved CPE credit. Candidates have to complete a prerequisite of 23 hours of project management education before sitting for this exam. So we know that they would, in fact, have that. The exam's 150 questions and 3 hours in length. The policy is to grant 5 times the length of the exam for CPE. And so this is a 3-hour exam. It would carry 15 CPE hours in the proposed technical field of study, management services. So we have approved the exams for the Certified Management Accountant, Certified Information Systems Auditor, and quite a list of other exams. And there's a restriction that this is limited to 50% of the CPE required for that particular period. So there is a limitation on this. Is there discussion?
With that CPA limitation of the 50%, that's of would that be 40 hours or 80 hours? I mean, I guess it's below both, so it doesn't matter.
Yeah, it would be the 40 hours.
The 40, okay. Okay. I was okay with this And I would make a motion to accept it unless there's further discussion.
I would second
I saw
that.
no reason we wouldn't. Go ahead.
I second Janet's motion.
Oh, okay. I'm sorry, I jumped in at the wrong time.
Mhm.
All right, can we have a roll call vote?
Pam Church,
Aye.
Janet Booker Davis,
Aye.
John Griesbeck,
Aye.
Gay Moon,
Aye.
And that is our final issue for our committee.
Okay, Pam. Now your committee drew the long straw, or I guess the short straw this time around.
We did.
And particularly in your debut as committee chair. So thank you for working us through the issues and allowing a good discussion to take place. And let me kind of do a poll of the members here as well as those on the phone. Are folks comfortable taking about a 5-minute kind of break here, and then we'll get through enforcement in the executive committee and finish out our business? So we'll convene at let's say 2:25 p.m. Central Time here. I'm showing about 2:18 on my watch.
It's okay for us on the phone to just stay on the line?
Yes,
Muted?
it would be encouraged. Just maybe mute your phones. Yeah.
This meeting is no longer being recorded or transcribed.
Thank you, Kevin. The first item on the agenda is the case and complaint report, which you have in your package. And it is color-coded and regarding the activity types and the status of some of the cases. But there are 10 cases against individual licensees and 6 involving CPA firms. I shouldn't say against. I should say involving licensees and involving CPA firms. And I think there's no action to take regarding this report. I do think it's very interesting that the number of cases continue to decrease. Wendy, you or Maria may have comments on that, but I see that as a positive.
Yeah, I really don't have anything to add. It is interesting to me as well, but I have yet to determine why that might be. We definitely have a decrease in CPE complaints because of the processes we've changed over the past couple of years, but that still doesn't amount to the decrease we've seen in complaints. So we'll take it for now.
There's also a column that lists the total age of each cases. And those that are longer, there are really good reasons for those. For example, you'll see the 2 that are coded in blue. One is on a payment plan for a civil penalty, and the other is a suspended license that must apply for reinstatement in 2023. So really no action to take at this point. And similar situation exists with the next 2 cases that are in legal litigation monitoring. I think there's no action to take. I don't know if anyone has comments. Okay. If we can move to the legal report. And you might also have available your legal synopsis, which is a 2-page summary of all the cases that we will go through today. The first section is the consent agenda, and I believe there are 6 cases under the consent agenda. The first is an unlicensed individual. Complainant alleges that respondent advertises as a CPA. Complainant stated that respondent provided incorrect tax advice and is not responsive to attempts at communication. Respondent submitted a response stating that she does not represent herself as a CPA and has never done so in the past. She stated that she prepares income taxes and payroll services only. Complainant provided no written evidence to demonstrate that respondent represented herself as a CPA, and there's no indication online to support complainant's claim. Due to this information, this matter is outside the jurisdiction of the board, and the recommendation from legal and staff is to close the case. And if it's okay with the committee, what I would like for us to do is vote on all the consent agenda items at one time after we go through the 6 cases. Case number 2, the board received a referral from the Tennessee Board of Licensing Contractors. The respondent provided a review report to the Board of Contractors dated April 19th, 2021. The respondent was not licensed with the board or enrolled in peer review. The respondent firm provides accounting, tax, payroll, and consulting services to clients. The respondent stated that the firm did not complete the review engagement. They only provided accounting and bookkeeping services for the client. When the client requested reviewed financials, the firm hired an independent contractor to complete the review since the firm was not properly licensed. The report was signed by the independent contractor, but the report was issued on the respondent's letterhead, and the firm's name was included in the signature block of the report. The investigator reviewed the matter, speaking with both the respondent and the independent contractor who completed the review engagement. Both parties agreed that the review engagement was completed by the independent contractor and not the respondent firm. The engagement letter was issued by the independent contractor, not the respondent firm, providing evidence of the intent of the arrangement. It should also be noted that the review report used I instead of we, signaling to the public that the review was completed by the contractor who signed the report. However, the use of the firm's name in the signature block and the firm's letterhead is misleading to the public. The independent contractor was licensed by the Kentucky State Board of Accountancy in September 2020, but does not hold a firm permit in Kentucky. The independent contractor does not hold an individual license or firm permit in the state of Tennessee and is not enrolled in peer review. And the recommendation is that we close with a letter of instruction to the respondent explaining that the firm letterhead should only be used when the firm has completed the engagement, is properly licensed, and enrolled in peer review. And the recommendation further is that we refer the independent contractor violation to the Kentucky Board of Accountancy. Comments? Yes. Okay. Case 3. Complainant alleges that respondent is representing herself and her company as CPAs, though through verbiage on her website. Complainant stated that respondent admits she is not licensed or registered. Respondent submitted a response indicating that neither she nor her company represent themselves as licensed CPAs or as a registered firm anywhere on their website nor in person. Respondent denies the allegations by complainant. There is no written evidence to corroborate complainant's claim on this allegation. The investigator reviewed the respondent's website and social media for compliance with board laws and rules. One employee was using the title tax accountant that was not licensed. No other violations were noted. As of the date of this report, respondent's business has been permanently closed and the website is not available, and the recommendation is closed with a letter of instruction. Okay, case number 4. The complainant alleges that a former employee violated a non-compete agreement by setting up an office of her own, despite a stipulation requiring an 18-month waiting period before providing accounting services to the public. The complainant also states that the respondent's website violates board rules by stating that the firm provides, quote, financial statements, unquote. The complainant does not believe the respondent's firm is licensed with the board. The respondent obtained legal counsel who provided a response to the complaint. The response states that the respondent's firm is properly licensed with the board and can provide financial statements to the public. Regarding the non-compete, the respondent states that no non-compete agreement was signed. The investigator reviewed the matter. The respondent's firm is properly licensed with the board and enrolled in peer review. There is no limitation on professional services provided by the respondent. Issues involving violation of non-compete agreement are outside the board's purview, and the recommendation is we close this case. You're being too silent. I don't know if we're Okay, item number 5, case 5. A complaint was received alleging that a former employee set up an office of her own despite a stipulation requiring an 18-month waiting period before providing accounting services to the public. The complainant also states that respondent's website violates board rules by stating the firm provides accounting services. According to the complainant, the respondent is not licensed with the board. While the fact pattern is the same, this complaint uses a different respondent than referenced in item, I think that might be item 4 above.
That should be item number 4.
Yeah, item
I'll
4 above.
correct that before tomorrow.
Thank you.
Thank you.
The respondent obtained legal counsel who provided a response to the complaint. Legal counsel states that no violations of board law or rules were found at the respondent's website. He states that the term accounting was used in conjunction with other bookkeeping services that fall under the level of services routinely provided by non-CPAs. Regarding the non-compete agreement, legal counsel has not been provided a copy of the agreement. The investigator reviewed the matter. The respondent is not a licensee and does not hold out as a CPA at the website. Any allegations related to a non-compete agreement would be a legal matter outside the scope of the board's purview. The recommendation is that we close that case. Case number 6. The board received notification that the respondent firm was dropped from the peer review program. The respondent was notified by certified mail to provide the board evidence of reinstatement to the program or to complete an affidavit for peer review exemption. The respondent did not respond, and the board proceeded in opening a complaint. Respondent submitted a response stating that the firm was dropped from the peer review program due to failure to pay peer review fees. The respondent indicated that their office was closed due to COVID-19 and the mail was being collected and received sporadically. Respondent has since made the necessary payments and is currently enrolled in peer review. The recommendation is that we close with a letter of warning.
Motion to approve consent agenda.
Second, roll call.
We need a roll call since they're not on, the virtual participants aren't on the committee, I think.
I'm not on the committee, but could I ask a question?
Sure.
On the second one, I guess if that's the most we could do, but that seems pretty bad, giving out your letterhead to somebody else to use it. But I don't know that there's anything else we can do in this case. I guess we referred it to Kentucky.
Yes.
That's on the second one. I guess I'm asking legal, is that all we could do?
We have the jurisdiction to, issue a civil penalty. I will say this respondent was extremely willing, almost overly, to want to be in compliance, and it did seem like a genuine mistake. So I think that was the mitigating factors here. But
that seems like common sense isn't too common anymore. That you would not give out your letterhead to somebody else to use, but I guess, as I say, common sense isn't too common anymore.
This is Rob Vance. I'm looking at I'm reading the complaint, and it doesn't look like it says that the respondent gave out the letterhead. I think in signature block it said it was just used. So we don't know if the independent contractor took it upon themselves to use the letterhead or what. It doesn't say here. Facts don't state that. So I think that's interesting.
What did it say about that?
I think the letterhead came in because the firm hired the independent contractor, and so I think it kind of all got wrapped into one.
Okay, I guess I was reading the respondent states that he did not realize that the use of the firm's letterhead would be a violation. Oh. So why would he realize that if he didn't? Anyway, I can let it go if nobody else has an issue with it. It just seems bad. And then on the third one, who is the letter of instruction going to since the firm is closed?
We still have, we can get the respondent's email address, and so we can deliver it that way, and then also ask for an updated mailing address.
Okay, I was just curious.
So I think we have a motion and a second, and we do not need a roll call, we think.
If we have quorum of the committee in the room, we do not need a roll call.
Okay.
Aye. Aye.
Greg, as we get into the second and third batches, the proposed disciplines and representations, if you want to synopsize cases, I don't think there's a need necessarily to read the entire case into the record, but it's up to you.
Case 7, and we are under proposed discipline now. Case 7, the board received a complaint alleging unethical conduct by respondent. The complaint was filed by the managing principal of the complainant firm, who is the respondent's former employer. During his tenure, the respondent was responsible for filing federal and state filings for both individuals and businesses. After the respondent's resignation in December 2020, the firm discovered that the respondent filed tax returns using the firm's software for at least 9 entities that were not approved by the firm's partner group. The complainant became aware of these filings in February 21. An email was received at the respondent's firm email address from an individual requesting copies of year-end closing entities for a group of entities. The firm had no records for these clients. After further review, it was determined the tax returns had been completed by the respondent using the firm's software and released to the entities via email. The complainant alleged that the respondent concealed the completion of the tax returns from the partner group by deleting the returns from the e-file queue in the tax software. Respondent states that firm encouraged him to attract and retain as many new clients as possible. To attract new clients, respondent often provided free services with the goal of attaining the clients on a permanent basis. The matter was referred to the investigator for review. Complainant firm was able to provide documentation of 6 federal tax returns forwarded to taxpayers by the respondent and 4 Tennessee franchise and excise returns, either forwarded to taxpayers or filed through TNTAP. The respondent continued to claim that complainant was fully aware of the engagements. However, the complainant alleges that the signing of returns by the respondent, a tax supervisor, was not in line with the complainant firm's policies and procedures. The investigator consulted with the AICPA Professional Ethics Support Group regarding the matter. AICPA advised that the actions warranted review under the integrity and objectivity rule, as well as the acts discreditable rule. The recommendation is that we authorize a formal hearing with the authority to settle via consent order upon the respondent's payment of a civil penalty in the amount of $500 in violation of Board Rule 20-03-.04 for failure to maintain integrity. We would also require the respondent to complete the 3-part NASBA ethics course within 30 days. Comments?
How did we come up with the $500 penalty?
This was a case that I struggled with a lot, not because I don't believe that the actions of the respondent are not egregious, but because there's a lot of he said, she said in proof, and I struggled with the authority of the board to discipline on this matter. And so we hinged on the respondent using the tax software without the firm's consent or ability to be billed for the use of that service. And so the mitigating factor we took into consideration was that this was a first offense. I am open to whatever you all may prefer on this, but the $500 was a mitigating, I guess, discipline, and hopefully to engage the attention of the respondent in the matter. And so if you all believe this is more, egregious than a $500 civil penalty, then I defer to you all on that.
This one is troubling to me because, number one, I can't imagine any partner group saying we're not going to bill that first year at all in hopes of retaining. And so I'm kind of wondering, did this individual know he was going to be leaving his employer and he would take these clients with him? And so he did that. And then the use of tax software and eliminating a trail or trying to eliminate a trail is troubling to me. I mean, particularly as a tax practitioner.
I'm with you. That part bothers me. The covering your tracks. So.
And I will say, just as a matter of proof and like moving forward in the event that the respondent does not agree to the civil penalty, a lot of it is inferred from the fact that, we can't definitively say he was intentionally deceiving and trying to conceal, but it's just inferred from the fact that it was deleted. The standard penalty based off the discipline matrix is $1,000. So if you think that's a more appropriate civil penalty. Or there's also, for aggravating factors, it could go up there.
Be more inclined to go with our standard penalty, but I don't.
Do you think?
If you have any questions, if you all did not realize, Sherry is on the phone. She just wasn't able to join us today. But if you have questions of her regarding the investigation, it's okay if they ask, correct?
The facts also state that respondent experienced significant health issues during 2020. I don't know if that's a mitigating factor or not.
This is Janet. I'm not on the committee, but I agree with Gay. These actions are troubling at least, and I would think the penalty should be at least $1,000, if not more.
This is Sherry. I will add something that is not in the write-up too. I mean, I understand legal's dilemma with this particular set of facts, but one thing that's not in the write-up is that the complainant firm actually went to the degree of contacting their liability insurance carrier, and for the clients, I'll say clients in quote, but for the organizations where tax returns were filed that they were unaware of, they sent a letter out advising those individual groups that they may want to get an independent tax accountant to review it, that it had gone past there. So I wanted to make the board aware that the firm took action even over and beyond what they're doing in terms of filing a complaint with the board. They took this very seriously.
Sherry, this is Gay. So in here it says the respondent was not approved to sign returns. Is that
right?
Was that for anybody, or was that just for these specific clients?
That was just, and I found that to be, somewhat standard practice in some firms. I don't know if it is for everybody, but usually, and then in the case of this firm, only the partners were signers on the tax return. And that didn't necessarily mean that they reviewed everyone with a fine-tooth comb, but they were the signers and took responsibility for the returns at the firm level.
And that was a normal firm practice for anyone other than a partner to sign a return.
Right. You may have somebody that's a preparer at the supervisor level, but they were signed by on the return. The signer was indicated as being should have been indicated as being a partner of the firm. one of the partner groups,
Sherry,
one of the members of the partner group.
I'm sorry, Sherry, this is Rob Vance. I have a question for you. I'm assuming these returns are filed electronically. I guess
Correct.
Okay. Was the
But these actually were not filed electronically.
Oh, they were snail mailed? Okay. Whose firm name was at the bottom where the signature was?
The complainant firm.
So he signed under the name of the firm, and he had no authority to sign in the name of the firm.
Exactly, and
Okay.
nor did he go through the e-file process. The firm had a policy that everything would be e-filed unless there was some reason it couldn't be. And basically, that's why there's a description in there about deleting it from the e-file queue. Basically, how the returns were delivered to the organizations is he printed a PDF copy and emailed them to the organizations.
I see. And so would these have normally been filed electronically?
Yes, absolutely.
Okay. Yeah, that's troubling to me. Thank you.
Yeah.
I think 1,000 is appropriate. Yes, I make a motion that we authorize a formal hearing with the authority to settle via consent order upon the respondent's payment of a civil penalty in the amount of $1,000 in violation of Board Rule 002003.04 for failure to maintain integrity.
I'll second that.
Just a clarification, we also have a provision to require a respondent to complete the three-part NASBA ethics course.
I amend my motion to add the require respondent to complete the 3-year part NASBA ethics course within 30 days.
Second.
Oh, I second that.
Favor aye.
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 Opposed, no. Okay. Thank you. Case 8. Note the date of the license, January 1st, 1960. So,
Sorry, that's not right. Obviously that indicates that it was issued a long time ago, but what happened is when we moved from paper records to electronic records, the dates didn't all come over, so unless we catch it, you have to manually go find the actual date.
The respondent completed an employee benefit plan audit for the plan year ended December 31st, 2011 that was deemed deficient by the U.S. Department of Labor. The matter was referred to the ASCPA and TSCPA. A joint ethics enforcement program action was initiated, and the matter was reviewed by the ASCPA Joint Trial Board in August 2020. Multiple remedial actions, including completion of 43 hours of CPE and pre-issuance reviews, were recommended. The respondent was also admonished and prohibited from performing peer reviews. In April 2021, the board was notified that the respondent's membership with the ASCPA had been terminated. The ASCPA Joint Trial Board determined that the respondent was guilty of violating Section 1.400.001 of the ASCPA Code of Professional Conduct. A complaint was opened and referred to the investigator for further review. The respondent does not deny the allegations of the complaint. However, he feels his firm has taken adequate corrective action to remedy the matter. The firm completed additional audit procedures for the engagement in question, contracted an independent CPA firm to complete a pre-issuance review, and issued a revised report that was accepted by DOL in December 2013. The respondent would like the board to consider the length of time that has passed since the deficit engagement, 8 years, and his multiple attempts to negotiate a more reasonable settlement with the AICPA with no success. Recommendation is authorize a formal hearing with authority to settle via consent order upon the respondent's attestation that he will not perform employee benefit plan audits under ERISA without prior notification to the board.
Done any other employee benefit plan audits since 2011 or performing it in 2012?
No, he has not, Gay.
Okay. I don't understand why it's taken 8 years.
So the process with the Joint Ethics Enforcement Program, I administered it when I was at the society, and it just takes a while. And they typically go through a prima facie evidence type process, and then if they have that, they will recommend a letter of corrective action, which has a bunch of things you can do, and they have to get agreement from the society, and then they finally send that out, and then the individual has to agree to it. And then they have to actually do all of the things. And many times there are a lot of things for them to complete in that letter. And then if they either don't sign it, don't agree to it, or they don't do some of those steps, then they end up going on to a full investigation and to the Joint Trial Board. And so, and then if the individual decides that, throws up their hands and says, you know, I'm done trying to work with you type thing, then sometimes, you know, they tried to get them to get through with everything, but it just takes a while. So, unfortunately.
And also, I had the privilege of serving on the trial board for, I think, 6 years, and what Wendy described is exactly how it works. And just my opinion only, but the trial board is very lenient and tries to work with folks to get them in compliance as opposed to issuing punishment. But
in my experience, that the DOL part of the process that initiated all of this can be a 1 or 2 year process after the report is issued, because they have to pick it, review it, and then basically litigate it and come to a conclusion.
So I think we need a motion and approval.
One quick question. I don't have a problem with the recommendation, but have we, I don't remember ever asking notice to perform something. I know we've said come back with litigation updates, come back with a variety of deliverables. This one was just a little bit unique. I don't have an alternative that I think is better, but was just kind of, I think is a unique posture. Just curious if there are other things you considered fashioning, but I think you landed in a spot that's okay.
We went with that recommendation. It kind of mimicked what he entered into with the TSEPA. So we thought he would be in agreement to also enter into that. And then we'll have a consent order, and there's an admission that this did occur, that he, and so it would be on record, and, I don't know. Recommend it if you all.
Well, does the board have any right to require him to cease activity, or is it just, hey, tomorrow I'm issuing, board, tomorrow I'm issuing a report, FYI, per the consent order? Is that all that's required, or is there some extra step that the board would have discretion or an obligation for?
The writing of the consent order would just be the notification.
My guess is he will not do another ERISA audit.
Yeah, you're right. Yeah. Okay. Well, I'll make a motion to accept this recommendation.
And I'll second that.
Favor aye.
Aye.
9. Board received a referral from the Tennessee Board of Licensing Contractors. The respondent issued a peer review report dated February 21st, 2020 for a client stating that the firm was not independent. The managing partner of the firm responded to the complaint, stating that he had no personal knowledge of the reviewed financial statements. They were reviewed by another partner who passed away in July 2020. While an independence violation is not present, the issuance of a review report with a disclaimer stating that independence is impaired is not in accordance with the standards. Professional standards would require withdrawal from a review engagement if the firm believes that independence is impaired. As an extenuating circumstance, it should be noted that the partner in charge of the engagement was battling stage 4 lung cancer at the time the report was reviewed. Accordingly, there are concerns about the partner's physical and mental state at the time he signed the report. The recommendation is to authorize a formal hearing with the authority to settle via consent order upon the respondent's payment of a civil penalty in the amount of $500 in violation of the board rule for failure to perform a test services in compliance with standards. Require all licensees in the firm performing a test work to complete 8 hours of CPE covering accounting and review services. CPE course should be approved by the board prior to taking the course. Proof of CPE should be submitted to the board no later than January 30th, 2022.
This is kind of interesting because we're having all the licensees at the firm that are doing a test work get CPE and not just the, do we normally ask the employees? I mean, normally it's a firm issue, so it's more directed to the owners.
I think you could go either way. I think that historically in peer review they've done both. So it would be, I think, Sherry, help me if I'm wrong here, but I believe because of the partner passing away, they were having to designate a new A&A partner. And so there was some concern about anyone there having enough A&A background that maybe they all.
Yes. I was going to say that's a correct statement. And to add to that, the individual who performed the review engagement also is no longer at the firm. So the primary concern was, is there somebody within this firm that has the adequate knowledge, skills, knowledge, and experience to do an accounting or review service?
But when I renew my license and I check the box, I do a test work, I have to show that I have 20 hours of A&A. So is this in addition to that, or is this, so they're going to have 28 hours?
This is CPE for accounting and review services only, not necessarily A&A, right?
Because A&A is really broad.
Okay.
So this would be mainly a SARS type course.
And I think we're not saying that this wouldn't count as part of their individual CPE.
Okay, this is not penalty CPE. This is just normal. Okay.
Yeah, under the SARS standards.
Right.
Only one partner left? There's only one partner left in this firm? Was it a two-partner firm? The other one died?
No, Sherry?
There is another partner with the firm, but both partners are more tax-oriented.
That was my next question. Okay.
Yeah.
Also, Kay, whenever Wendy and Sherry and I meet monthly to discuss these, the discipline was recommended by Sherry or Wendy just because I think the SEC will sometimes do this for discipline. Is that
peer review?
So sorry, for peer review. Sorry. And so we just kind of mimicked that we just got the notion, I guess, or the vibe that maybe this would be helpful for these individuals to complete.
Well, would it be better to have the CPE related specifically to the SARS that covers review and compilation or audit services?
And it is. The recommendation is the 8 hours of CPE covering accounting and review services.
I mean the SARS in particular that covers that, because there are specific SARS courses.
Janet, we had that conversation, and I was hesitant to use SARS 21 since there's been a couple of updates since, and I wanted to make sure they had the updated guidance. A lot of times we'll say SARS 21.
Right,
but,
yeah. Mm.
We could just refer to the SARS, right, without...
Yeah, we could do that.
Yeah.
Wasn't this related to issuing a review?
Yeah, but those statements cover...
Okay. Oh, okay.
Compilation and review services.
One thing, I mean, it does allow us, if as currently worded, to basically give prior approval of the course. that they're going to be taking, and I think that probably would be adequate. I think we all agree that SARS directly related training related to their reviews is appropriate.
I just want to be.
And so the board, or so the respondent self-reports as to what members of or what employees of the firm are going to be taking these courses. So it could be 1 or it could be 15, right? Okay.
I just need clarity, sorry, on what I should replace language-wise. So 8 hours of CPE for just to say SARS instead of covering accounting and review services.
And that language ultimately is okay as is.
Got it.
Yep. I think. Right.
That's what I can help you with that language for you.
Okay.
Make a motion that we accept the recommendation of the staff.
I'll second that.
Favor aye.
Aye.
Thank you. Opposed, no. Okay, case 10. Board received a referral from the Tennessee Board of Licensing Contractors. The respondent provided a review report to the Board of Contractors dated March 31st, 2021. The respondent held an active individual license with the board on the report date. However, he did not hold a valid firm permit and was not involved in peer review. The investigator reviewed the matter. Based on his LinkedIn profile, it appears that the respondent has not worked in public accounting since June 2015. The investigator requested employer information from the respondent and reached out to the employer to confirm employment. The employer stated that the respondent was contracted to provide tax services only, and she had no knowledge of the review engagement in question. The owner states that the firm has never completed a test engagements. The firm has a peer review exemption form on file with the board. During her review, the investigator noted that the format of the review report was not in accordance with current guidelines, and the respondent had failed to obtain an engagement letter for the review. The recommendation is to authorize a formal hearing with authority to settle via consent order upon the respondent's payment of civil penalty of $1,500 for violation of rules, including for issuing a review report without a valid firm permit. Require respondent to complete 3-part NASBA ethics course within 30 days. The $1,500 penalties for violation of several of those provisions, right, Maria? Right.
And recommendation for the civil penalty is going to the CPA, who is the employee in a firm. Is that right?
He's an independent contractor.
Okay.
So the complaint is against the individual and his capacity as a CPA.
Thought he was working under the umbrella of.
Yeah, which is why we recommended the ethics course.
Yeah. Okay.
And Gay, he did issue the report in his name only.
Okay. Oh, okay.
I was going to point that out. In contrast to the other ones, another one we talked about, this was in his name only, or her name only. Make a motion that we approve the recommendation of the as so stated.
I'll second that.
Favor aye.
Aye.
Opposed, no. Thank you. $11. The board received a referral from the Tennessee Board of Licensing Contractors. Seems like there could be a pattern here. The respondent provided a review report to the Board of Contractors. The respondent held an active individual license with the board on the report date. However, he did not hold a valid firm permit and was not enrolled in peer review. The recommendation is authorize a formal hearing with the authority to settle via consent order upon the respondent's payment of civil penalty of $1,500. violation of the various sections that you see in your.
And I just want to note, when individuals issue these reports without the perm permit and enrollment and peer review, we sometimes recommend the ethics course, the 2-hour state-specific ethics course, but we were able to verify that he has already taken that, so that's why you don't see it in the recommendation.
I'll move that we accept the recommendation.
Second.
Second.
All in favor, aye?
Aye.
Aye.
Okay, that's all of the proposed discipline section, and then we have two cases on the representations. Case 12, the board received a referral from the Tennessee Board of Licensing Contractors. I think we can go down to the new information section. Respondent's attorney contacted the board attorney and indicated that respondent wishes to address and resolve this matter by agreement. However, there are additional facts that impact the terms of the proposed consent order, specifically the provision requiring a completed peer review. According to the respondent's attorney, an irreconcilable dispute has arisen between the respondent as majority owner of the firm and the minority owner. There is currently effort between both parties' attorneys to dissolve the firm's existence. The firm is not currently providing any attest services or accounting services for any client, and it does not plan to do so going forward. The current proposed discipline requires the respondent to provide proof of an accepted peer review by February 2022. Due to the information received by respondent's attorney indicating the proposed termination of the firm, this language should be removed as a provision of the consent order. So the new recommendation is to authorize a formal hearing with the authority to settle via consent order upon the respondent's payment of a civil penalty in the amount of $1,500 for 2 counts of issuing an attest report without an active firm permit, and then require the respondent to close the firm permit.
Make a motion that we accept the new recommendations.
Second.
Second. Favor aye?
Aye.
Last case. Board received notification that the respondent entered a guilty plea to 1 felony count of use tax evasion after an investigation by the Tennessee Department of Revenue Special Investigations Team. Respondent was required to remit the unpaid use tax and was sentenced to 1 year of unsupervised probation. The complaint was open to explore the matter further. Then let's go to the first paragraph, new information. Respondent requested an informal conference with legal and board member Kevin Monroe to discuss the disciplinary action assessed against him in hopes of resolving this matter. The informal conference was held on September 29, 2021. At the conference, respondent admitted that his actions should not have occurred. He contended that at no time was the public at harm or impacted by his actions. Based on the informal discussions, respondent requested that the board modify its proposed discipline in order to allow the firm to continue as it currently operates so as to avoid harming the existing employees. Respondent's firm currently employs 9 employees, 3 of which are licensed CPAs. Respondent expressed that he does not want his employees to suffer as a result of his personal choices, and he would like to absorb the discipline in order to avoid any disruption in the operation of the firm. In lieu of suspension, respondent requested that his license be placed on probationary status. He also proposed additional continuing education in the area of ethics, as well as an increased civil penalty. So the new recommendation is authorize a formal hearing with the authority to settle via consent order with the following provisions. suspend respondent's individual CPA license for 1 year effective the date of receipt of the signed consent order, require respondent to appear before the board if reinstatement is pursued, require respondent to pay $2,000 civil penalty in violation of two board rules, require that respondent complete 3-part NASBA ethics course prior to December 31st, 22, allow respondent to be able to maintain his current firm name throughout the suspension period, and finally require respondent to provide proof that he has relinquished majority ownership in the firm within 30 days of signing the consent order. And Kevin, you may have comments on this case too.
I do. I'll just briefly highlight what happened, and also because I participated in the informal conference with the respondent, I will need to abstain from the vote tomorrow that the board ultimately takes when it addresses this. But we met with the respondent and his legal counsel, and also with Maria and Wendy. The respondent fully acknowledged guilt. He did not deny the violation. He did indicate that the violation occurred prior really to the growth and development of his firm and the employees and so forth, and it took 3 or 4 years for the violation to be caught and adjudicated, through the processes here. And in that time, this firm, had grown up and it's got other people and employees involved, and he was very, I think, sincere in his view that he did not want the firm to suffer. There were 2 issues that we discussed, or at least among 2. Recall that we had a similar disciplinary case against another CPA involving an airplane where he had done the same thing. He had basically fudged the invoice so as to minimize the sales or use tax on that transaction. And that person was suspended, but he was not an owner of a firm. So there is a kind of a different fact pattern there. But, for a CPA to basically perpetrate tax evasion, willful tax evasion, to me, that still, I did not think that probation was an appropriate recommendation to make to this board. And I still don't believe that. The board will need to make its own determination. There were 2 concerns that were expressed if suspension was undertaken. One was, would it compel the firm to change its firm name? Because I believe the respondent and his wife own 80% of the firm. His wife is not a CPA. So if you take his ownership out under suspension, then it falls below the 50% threshold. That's one. But the other issue is that they would, because he was, no longer the owner of the firm, would the firm need to change its name? And that was a concern on his part. As we looked at the rules, we felt that there was some discretion, there is discretion on the part of the board to allow the firm to maintain its name, at least for the circumstances that we're recommending, and that was the one kind of concession that I was comfortable recommending, so they wouldn't have to change the firm name and email to their clients and customers here during his period of suspension. But he's still going to have to address the ownership issue while he's under suspension, and in my view, that's a consequence of the act that he perpetrated, and so therefore I'm comfortable continuing to recommend suspension. I'm happy to respond to any questions that any board members may have about the informal conference that I can.
Comments or
Nothing, no action is being taken, unlike the prior recommendation under the revision, no action is being taken with respect to the firm permit.
That's correct, yeah. We're allowing also the firm name to remain the same, even though the named owner is under suspension.
Is he going to be allowed to obtain any ownership after the 1-year suspension, or retain ownership?
That will be contingent on his reinstatement. That if the board would then reinstate his license, he could proceed in getting back the majority ownership.
But he will have to apply for reinstatement. If we suspend, he has to apply for reinstatement, and the board has, the board can choose whether to grant it or not, or set conditions.
My reading, I guess, reinstatement for a felony conviction has a lot to do with the crime that was perpetrated, had to do with the accounting profession.
I do want to make one caveat to that statement about the felony conviction. I believe he is eligible for judicial diversion. So in the event that he goes this whole year, he's on unsupervised probation. At the end of that period, if he doesn't have any offenses, this will be eliminated from his record effectively, and there will be no conviction of felony against him, which is the exact same fact pattern as the other respondent who committed tax fraud.
So we tend to go for fiscal dishonesty as the violation rather than felony conviction.
This is not accounting per se, but it has to do with use tax, and he knew the difference. He knew what to do, and what not to do.
Does not deny the violation in any way, and that was the first statement that he effectively made in the informal conference. He understands that it was a violation, that he shouldn't have done it. He regrets doing it. But in my view, the request that he made for probation, given the seriousness of the violation and the precedent that we'd had on a somewhat similar case, I just didn't feel in my heart that I could recommend probation, in other words, non-suspension, to the board.
Looks like he's paying a pretty high price with all of these recommendations, to me. I would think so.
And he also indicated with his attorney present that he had to make restitution, effectively pay back not only the tax, but I think essentially 100% penalty on the tax plus interest. That's been resolved. And so, my sense is that I don't think he is likely to commit a similar violation in the future. But he's a CPA, and this is an overt, tax-related dishonest act, in my view.
All right, do you have in front of you the rules or statutory language about ownership? I didn't see that loaded on our iPad, but if you don't have it up in front of you, don't worry. I just wanted to parse that piece of it.
Yes, I can pull it up, but I think I know what you're getting at. So we discussed this in the informal conference, basically that the firm ownership would have to go to a CPA in the firm. If, the board didn't go for his probation. And so under this recommended discipline, he has to relinquish that majority ownership.
The 20 minority owner is a CPA.
It's actually two CPAs at 10% each.
Oh, okay. They're both CPA.
Yes.
I have to appreciate him taking on a lot of this responsibility to protect those two that came along after this happened that had nothing to do with, and potentially, I guess, any employee.
He relinquishes the ownership to those two, no telling what might happen. Those two, they're going to be 50-50 owners, sounds like, or someone else is.
Well, his wife could retain some.
Yeah, his wife currently has a 40% interest in the firm. She is not a CPA. He had 40%, she had 40%, and these two other owners each had 10%.
Presumably, they'll be elevated to 60% then.
Or 50 plus 1, yeah.
Right.
I'll have to work out the arrangements for that if that's what this board adopts. But to me, that's a consequence of an act, and it's regrettable. But I felt this was kind of a middle ground between, having them, go full bore and change the name of the firm and potentially confuse their clients and things of that nature. But I also felt strongly that suspension was still warranted.
I completely agree with suspension being warranted. I'm thinking about the practical aspect of maybe interim transfer of ownership, maybe not, who knows, and whether that's fair to the other two, but I think that's beyond what we need to consider. So I think it's we've at least given them a path, and it's their choice to figure out what makes the most sense for their situation. This is where I've kind of talked myself into a circle at least, but I think this is a fair compromise given the ask and all the other factors.
Hey, Kevin, this is Janet. I think you were saying that, I don't want to put words in your mouth, that you got the sense that he has, I guess, learned some lesson and won't perhaps repeat something like this again, or this in particular. But did you get a sense of what motivated him to do this in the first place?
Oh, we didn't, Janet. It's a good question. We didn't really explore that overtly on the basis that, I mean, he effectively admitted that he was basically trying not to pay the full share of sales use tax that would have been paid on that transaction. So I'm assuming it was pretty purely pecuniarily motivated to save, try to shave money on the transaction, just from
I didn't know if he might have been under some financial distress, or, sometimes there are extenuating circumstances that might inappropriately incent a person to take an action that they may not otherwise take. But, if you didn't get a sense of that, that's fine. We didn't get a sense of it, and he was purchasing a houseboat. To me, that I don't think that was the primary domicile of the family. Yeah.
And this could easily be $100,000.
So the houseboat is $146,000 was the purchase price.
Times use tax, that's probably $100,000. It could be $100,000.
Oh, so sorry.
I mean, excuse me. That would be
$30,000.
I'm sorry.
As far as the
I'm
purchase
an accountant,
price.
excuse me. Yes, 30 or 40. Yeah, $30,000. I'm sorry. Okay.
Janet, this is Sherry. To address your question a minute ago, usually in these cases, I ask, and in this case I did, if there were any extenuating circumstances, and the respondent just basically said it was a lapse in judgment.
Okay.
Now, that doesn't mean there weren't any. He may not have been comfortable sharing them, but I usually ask that question in these circumstances for that very reason.
Yeah. Okay, thanks. I appreciate that.
Just one other thing I wanted to say. I mean, with this new recommendation, my thought was, Todd, what you were saying is just for ease of the business and maintaining the status quo, because I know that the firm name is included in all of the email addresses, website, and so that would be a way to help the business stay afloat with all 9 employees, and then in the event that he does seek reinstatement and is reinstated, then he could go back to that. And so that was the main intention here. And I thought that the facts were a little bit different from the previous respondent, just because the previous respondent with the airplane, he didn't have a business. And so that was just another consideration that I wanted all of you to be aware of.
How did we determine a one?
It was going to be until December 31st, 2022. And then Wendy brought up a good point that you could hold the consent order and not sign, and then you're like, sign it November 1st, whatever. And so it was a good way to just set a strict timeline. Then that would incentivize you to move on it and go ahead and sign the consent order rather than wait it out.
Man imposed on you to
oh shit.
We have a second.
I'll second that.
Second. Those in favor of Aye?
Aye.
Thank you. Mr. Chairman, I think that concludes the actions of the committee for today.
Okay, thank you very much, Greg, and thank you for taking on the role of assuming the chairmanship of this committee, which generally has a fair amount of activity, so thank you. The next committee and our last committee meeting this afternoon is the Executive Committee, which is comprised of the officers of the board, and most of the items here relate to the fiscal updates. Now that we're beyond the end of the fiscal year for fiscal year 21, we will have an update also as the last item on the state-specific ethics course outline, which will require action here. And so, Wendy, I'll turn it over to you with respect to the fiscal year 21 results and year-to-date results for fiscal year 22, and then the proposed budget for fiscal year 23.
Okay, thank you, Mr. Chairman. I regret to tell you that we do not have any year-to-date information, or very limited. We received some information for August, but it was still missing a lot of expenses that normally come through, July. And we do not have August numbers yet, so there wasn't much to provide you all. So what we're going to do today is just review quickly our preliminary results from FY21, so as of June 30. And again, we're still waiting on the final closeout, but these are pretty close. It should be within just a few dollars if there's any changes at this point. So you will see I have a column for preliminary numbers there, and you'll also see the prior 4 fiscal years. We had a total expenditures of $810,283. That's comprised of $616,000 in direct expenses, such as salaries, travel, rent, car, computer equipment, those types of things. And then there are cost backs, which are related to the Assistant Commissioner's Office and the running of the regulatory division. And so items included in the cost backs include administration, legal, which is Maria's time and everyone involved in legal. We have paralegals. Of course, you all saw Tony earlier. Some of his time is included there. Customer Service Center, those when a licensee calls in to our main number, they a lot of times go directly to the Customer Service Center. If they're busy, they may get our staff. So our staff takes about 60% of the calls, and customer service takes about 40% of the calls. If customer service cannot answer the question, they are forwarded to a member of our team to help with that. So from that standpoint, we had an expense of $17,000. Centralized complaints also is a centralized division. When someone files a complaint, we have a centralized division that handles the administrative side of that, requesting the response, keeping up with the response, sending a past due letter, forwarding all the information to the legal team. And so our specific staff doesn't get involved in that. And so the expense there was just $2,800. As you can see, that kind of corresponds with our decrease in the number of complaints that have been filed, where the previous couple of years we've seen an expense around $6,000 or $7,000 versus the current expense of $2,800. So total cost backs came to $194,000, which we'll see in a few minutes, and you can see across the line there that's a little low for cost backs over the past several years. So we've been as high as $281,000. Maybe more typical is around $225,000. So I hate to think that 194 is actually where we'll be. It would be nice if it was, but I do think that's a little lower than normal. From a revenue standpoint, total revenues were at $964,000. The licensing revenue was at $1,015,000, and then we had case and complaint revenue of $21,000. That also, of course, with lower complaints, is lower than we have seen in the past several years. We topped out around almost $53,000 there. And then there's the reg fee, which is a standard fee that's assessed for all active all issued or renewed active licenses, individual licenses. and a fee for firm permits. And so that stays relatively steady there at $71,675. So we ended the year on the plus side at $154,000. That added to our reserves of $1.411 million, leaves us at $1,566,045. $1,566,045. So of course we don't like putting that much into reserves, but we didn't have any travel, which is typically around $35,000. Our cost backs were lower than normal. So there are still some things we will probably see going forward, and hopefully that number will not be as high going forward. So as far as our year-end numbers there, are there any questions? Anything I didn't point out that kind of raises a flag? So yeah, so we're skipping over where we are current year because we really don't have much. And so we'll go into a budget for FY23. So that'll be July 1, 22 through June 30 of 23. So I have the documents that I provided for you was a budget document which just shows from a column standpoint what our budget is in the current year, what our preliminary results were for the previous year, and then actual for FY 19 and 20 as well. And the accompanying documents, we have attachment A that talks about our salaries and employee personnel budget, and then also have more specifics on travel. And then we also have a summary of each of the line items. So I'll just kind of walk through those quickly, and you all can ask questions if you have any on any of these. And this is a lot I know a lot of you have heard this, but Rob hasn't heard this before. So going through these, if you have questions on what falls there, let me know. Revenues for the proposed year, I am recommending that those are flat to the FY21 year, which would be a comparable renewal volume. And really the best we can do there from a revenue standpoint. Of course, we do not include case and complaint money in our projected revenue number. There's a chance we would have 0 complaints and 0 civil penalties, so the department does not like us to include that in our revenue number, even though in reality we rarely see nothing in that column. So that's kind of the difference there sometimes when you see the budget compared to, for instance, our preliminary results this year. Under the state reg fee, there's an explanation there. It is $10 for each individual license that's issued or renewed, and then there's a $5 fee assessed for the active firm licenses. That's because firms renew every year rather than every other year. And that particular fee covers the indirect costs for the entire department, so from HR to the commissioner's office, so the higher level fees or costs associated with the department. All right, so in the salaries, this section is at $381,000, assumes a staff of 4. That's myself. I'm sorry, staff of 4 and myself and an investigator, so we have a total of 6 on staff. This also assumes a 3% compensation increase at one time during the period. So we've had an odd history with this over the past year. So they had suspended raises because of COVID. Then they reinstated them this past summer and added more than we thought they were going to add. And then now there is likely not going to be increases in January, but some potential bonuses. And then we're just not sure after that what they're going to do exactly. And so this is, again, not an exact science, but just to get some money in there. I seem to be behind. It seems to be the only budget item that we are unfavorable to because I don't budget enough in there. So I put in that 3%, hoping to make sure that we weren't behind in that line item. And your attachment A, I believe, talks about that a little bit. So we talk about the salaries of the staff, an increase there, longevity, which is a payment of $100 per year for certain employees that were hired prior to June of 15. They have to have 3 years of service, and they receive $100 per year of service. And then also bonuses fall into that longevity line item. So we have a budget there of $10,000. And then our total benefit computation is typically 37% of that salary line item of 387, but we've been running higher, so I am computing that at 42% of salaries. So our estimated benefits, employee benefits, is at $162,900 based on how we've been trending. And so the bottom section of Attachment A also takes into account that we do pay you $50 per day of meetings that you all attend. So that's in there. We just talked about employee benefits. Travel, you also have a travel attachment, and it outlines just by month what we expect from a travel standpoint. This is obviously assuming we get back to normal and we start traveling again. And your biggest expenses, of course, are NASBA meetings. We have 3 big meetings a year: the annual meeting, the executive director and legal conference in March, and then the regional meetings in June. And so this particular plan is planning for 4 board members to attend those meetings. So if we were to raise that number, we will need to come back to the board and ask for more, an allotment for additional individuals to go. During the executive director and investigator attorney conference, it's typically myself, Sherry, and Maria that attend that conference. And then I do have a line item in there for me to attend TSCPA's convention. We also have a limited amount for investigations. We have not been using it. Sherry has been doing a lot at home and able to do it successfully that way, so we haven't needed too much from a travel standpoint, but there is some there in case that needs to happen. And then, of course, your expenses as board members for attending the meetings comes to $11,500. So that handles the travel budget and brings us in at a total of $41,500. For the rest of the line items, communications and shipping, we don't expect any changes there. Of course, that's our postal charges, certified mail, and the mailing of our wall certificates. Third-party professional administrative services, this covers shredding, expenses with formal hearings if we have them, GPS service on the car that Sherry has, collection agency services, NASBA dues, that's a large amount of that, that's at $6,000, and then credit card processing fees are also another large item under that heading. Supplies and furniture, we're just leaving that fairly typical of prior years. We haven't needed a lot with us mostly working from home. Rentals and insurance, we do, if I go to Knoxville per se, I have to rent a car, so we have a line item for that. Awards, any awards that we may order for board members or staff. Unclassified used to be the professional privilege tax for CPA staff members. Of course, that's gone away, and so we have a 0 there. Employee
for some professions.
Oh, I'm sorry. Forgot to highlight Todd and Maria.
Not to be bitter.
Better lobby than you do.
Employee training is paid CPE for professional staff. This also, the biggest part of this is our registration fees for NASBA events. So for every person that attends event, it's currently at $695 per registrant. Computer-related items, we do expect in the FY22, we had a $10,000 budget there. I believe 4 staff members are receiving computer upgrades in this fiscal year, and then we'll have 1 left in the FY23 year, which is why I dropped it down to the $5,000 mark. State professional services, this is kind of a lump all for several things that we do with the state. So it includes our rent, our IT support tickets. So any support tickets that we put in, IT related, that are directly related to our board, fall here. That is an increasing cost for us, just because everything we do is related to our platform, and we have issues that we have to work through. Telephone billing, judges for hearings, state vehicle printing services by the state to print our wall certificates would go through here. And yeah, I think IT is the main reason that stays elevated there, as we've seen increased costs there. We do expect soon to see rent come down again. We will be moving the first of next year. They're going to consolidate our space even more. So my understanding is we should see a noticeable decrease in rent come sometime next year. So that will probably help us out. From a cost back standpoint, again, this is very, very hard to budget. It's one of those things that we can't really control, and we typically just go off of trends in this area or what we know may be coming down the pike. The one good thing to note from a technology standpoint, our licensing platform, as you all probably know in your own IT world, you have to undergo upgrades quite often to keep up with everything. So they are looking at a pretty extensive upgrade to our platform to happen in the next year. However, there was legislation passed this prior legislative season that is going to allow us to use reserve money for some of these one-time improvement type things rather than just maintenance type issues. So that's really good news, because in my tenure here working for the board and or attending the board meetings, we have not been able to use our reserve money for much of anything. So this is good news. So hopefully that will help us going forward. And of course, the summary of all of that is that I have our net revenues at $943,000 and our total expenditures at $942,908, leaving us with a $92 on the plus side. And that is what I'm presenting you today for a proposed budget.
Thank you, Wendy. Any comments or questions on the items that Wendy has discussed?
On the travel, didn't we have 5 board members who were wanting to go to the annual meeting?
Did we vote on that at the last board meeting?
We did.
Because
yes.
we did. Okay.
Yeah.
Okay. So I think I planned there $2,000 per board member is what we would need to add to that. So I missed that if that's what we did, and I think you're probably right, Janet.
I think that was to attend the meeting here that would have taken place later this calendar year in fiscal year 22.
Right, yeah, this one coming up.
So that's kind of mooted since that's no longer going to be an in-person meeting, right?
So what we could do is we could leave it as is and then wait till next July and determine how many people are interested in going, or we could go ahead and make the change in order to make sure we're already in a position to allow 5 board members if that's the case.
Well, yeah, that I guess that's what I was thinking, to do it now, since that was how many.
Janet, I think that's a fair point. I'm comfortable with that. If the other board members are, I think today, I guess it's technically the executive committee that's going to approve the budget and recommend it to the full board for consideration tomorrow.
Okay.
So that would involve, I guess, modifying would that come under the travel budget, Wendy?
Correct.
So we would effectively be adding $2,000 to the proposed fiscal year 23 budget, making it $43,500.
Correct.
Okay.
Does that cover registration fees too?
That is separate. So it falls under that. It doesn't fall. The registration fees do not fall under the travel line item. It falls under the education, the training of state employees.
So, Andy, I guess I'd look for a motion to recommend the proposed fiscal year 23 budget to the full board tomorrow. Okay. Okay, thanks, Andy. And since there are only two of us here, I'll second that motion. I guess all in favor say aye. Aye. Okay. And the full board will get a chance to formally vote and further discuss tomorrow at their privilege. The last item that we have, Wendy, if you don't have any other fiscal items, is going to be the state ethics, state-specific ethics course outline overview. And Wendy, if you want to kind of just introduce this topic in terms of what we're doing, this will also be an action item because the board has to approve basically the revised outline for the state-specific ethics course.
Sure. Okay. So what we've been doing each year is back several years ago, the board authorized a course developed by TSCPA to be provided to licensees across the state to meet the 2-hour state-specific ethics requirement. They also, the board entered into a memorandum of understanding with TSCPA that they would make that course available to other sponsors by which they could purchase the content that was developed and they could deliver it. But in essence, there's only one course from a content standpoint that's available to licensees. And we did this to provide some consistency in the content that was being delivered and to ensure that licensees were receiving the correct information and information that we found appropriate and of utmost interest currently to the licensees. So we had found when there were numerous courses out there that they weren't covering new content, they weren't even sometimes covering content related to licensees of Tennessee. So we had some concerns. So what we've been doing now is kind of doing an update of how that's going each year, referring back to the memorandum of understanding, touching base basically on comments we've received, and then we look at the outline that we would like TSCPA to use over the next year to create the content for the following year. So in my overview sheet here, everything seems to be business as usual. The course does cost, provided by TSCPA, does cost licensees $40 for the online version. They deliver it via webcast replay, and in a live version. I believe they're back to potentially doing that this year. The following sponsors have been approved to present the instructor-led course for this current year, and these sponsors are consistent with prior years, so we don't have any new entrants into the market. These are folks that have done it in prior years. So Beacon Hill, Becker, Checkpoint Learning, which is Thomson Reuters, CPE Training Consortium, Kaplan Smart Pros, MTSU does a live event, and Perry Moore does a live event. We have allowed MTSU and Perry Moore, or anyone doing a live event, to do an online version of a live event. So they just can't record it and replay it, but they can offer it virtually if need be. We typically remind in the fall the sponsors, if they haven't been providing evaluations, remind them they need to be doing that. We seem to get pretty good feedback, and they submit evaluations typically monthly. They're not a lot of information included in those evaluations, but I've kind of noted the feedback below. We've received feedback from Beacon Hill, or evaluations with positive comments. Becker had a later start in producing their course this year, so we haven't had any evaluations yet. Checkpoint Learning, they're probably the most active user, and they send in monthly evaluation reports. No specific comments or concerns from them. Kaplan's course is not available yet, although they've been approved, and I believe Perry's only had one course to date that he's been able to submit comments for. And so attached to the documents are just a reminder of the memorandum of understanding, and then we get to the outline that we are proposing for the upcoming year. We really don't have a lot of changes. The outline really remains relatively unchanged. I talked to Kara a little bit about that at TSCPA, and she, of course, felt like at least creating new case studies and kind of changing the look and feel of it was important. But from a content standpoint, I did note in red some items that we should probably add in there or consider from a case study standpoint, because maybe there's something we've dealt with in the prior year. So, of course, we've had a continuing education rule change that was effective October 6th that we would want to include in there. Fairly minor, but we would want to include that in there. And then under J, enforcement case examples or general case studies, in red, we kind of note some things that maybe to highlight. Changes in the code of conduct. There have been releases from Peak that change some things in the code of conduct, specifically on record requests. There's a new interpretation. There's staff augmentation changes. That doesn't affect a ton of folks, but might be worth considering how we could present that in the form of a short case study. And then we've had several things come in this year that were really outside the board's jurisdiction. So it might be a good case study to cover some of the things such as non-compete agreements that the board doesn't really have purview over, as just a learning opportunity in the ethics course. So I'm open to anything. If y'all feel like there's content out there that we're not covering appropriately, we can certainly highlight that, add that in here. I'm open to suggestions.
Thanks, Wendy. Any comments or questions or suggestions?
Does it deal with contractor license renewals?
So could I had the same question? Could that be put under D? Could we enumerate that?
Well, it's in there. Like,
okay.
It is in your face in the course. Yes, it's in there.
It's explicitly covered.
It's explicitly covered in the course. So that's why when someone has this violation that's an licensee, I go back to see if they took the course. And then I wonder how they took the course and then committed, the violation. So only so much we can do, I guess. But yes, we will continue to make sure that's highlighted.
One other thing along those lines is I know, Wendy, when you're meeting with chapters or when I'm asked to present to the TSCPA Council, I usually go over the list of the most common violations, and that's brought front and center. Of course, in those venues, we're generally preaching to the choir. I understand that because council members are probably more likely to be a little bit compliant than some of our folks that don't know the difference between a test and non-attest from time to time. Any other further questions or comments?
Just a quick question on the memorandum of understanding that we entered into. Of course, it says if we did come to a conclusion now that we didn't want to offer it through, then we'd have to give an 180-day notice. So then if we were to give that notice now, we would still be binding for another year. That's on second page, term 9 of the agreement.
Correct. So that's 6 months. Yeah.
Yeah.
Yes.
So I guess the question is that I know we can't do the course outline earlier during the year, but do you think we should bring this before the board just to see if we want to continue before that date, so that that would almost put us like in our April meetings to say, hey, do we want to continue what we're doing with CPE with our memorandum of understanding, so that if we ever did have a disagreement, then at that point we could give them the 180-day or the 160-day notice or 180-day notice on the contract, or do we just want to amend that and say, hey, listen, guys, we probably just need to be able to give a 60-day notice so that we can. Because here the term, I guess, starts effective January 1st. I know their season doesn't start till April 1st, so we could keep the 180 if we could date it to say, hey, it's an agreement effective April 1st, and then I think our time frame would be closer. But that's just a thought. I don't see. I think that the Tennessee Society of CPAs does a great job with this course. They work with us. I can't see us partnering with anybody else on a memorandum of understanding to give the course because they have a vested interest here in the state of Tennessee. Obviously the price is very fair, and so that's the only thing. It's just that from a board standpoint, could we really do anything for a year and a half?
So keep in mind that this MOU, as I will shorten it to, is really to ensure the board that there is a course out there, because it doesn't prohibit the board from approving other courses, but what it does is it ensures that since there is a rule that requires licensees to get 2 hours of state-specific ethics, that since we have limited the approval to one course, that course will be available. And so, if we want to do a different timing, I guess I just prefer to give more notice if we decided to go in a different direction, because that's going to cause a lot of things to have to change.
Yeah. And that's fair.
Yeah.
I was just questioning that. So.
Yeah. And, if that's something the board wants to talk about, we could certainly do that. And maybe that's more of something that we would address for maybe the for the 23 calendar year, so that everyone's has enough advance notice for something of that nature.
And I would say that if we did give a notice, that then they would be obligated to stay the course, if you will,
right,
until we get somebody else to provide it. But that would, so it kind of works in our benefit then.
Right.
Okay, so that's good.
Right.
I think the action that would be required is for the executive committee to recommend the Tennessee State Specific Ethics 2022 outline to the board for approval at its meeting tomorrow. And Andy, if you're comfortable with that, okay, I'll second that. All in favor, say aye.
Aye.
Aye. Okay, that's the recommendation will proceed forth. I think those are the last items that we have for our committee meetings this afternoon. I think our meetings start at 8:30 a.m. tomorrow. Is that correct?
That is correct.
8:30 a.m. So we'll see everybody, and hopefully in person or via the webcast tomorrow morning. And thank you, everybody. And again, Rob, welcome to the board. So.